Good morning, Judge Meyer. Please, please switch on your mic. These people should have done that for you. Are you well?
I'm good, thank you, Chief Justice.
You have been here before, haven't you?
Yes, I've been here before twice.
But let's touch on some of the things we had traversed before, as if we're not aware of them. I think it will help. When did you become a judge of the High Court?
Chief Justice, I became a judge in November 2007, but prior to that I acted for 6 months. So I've been a judge now for almost 11 years.
I've heard some practitioners say becoming a judge is no different from declaring insolvency. Why did you choose to be a judge?
Chief Justice, I miss the fees that I earned at the bar, but I must say the past 11 years were probably the best in my life.
Yes.
I became a judge in order to serve the country, and I get a lot of satisfaction because I know that I succeed in doing so.
What is it that fulfills you about being a judge?
I beg your pardon, Chief Justice?
What is it that satisfies you about fulfilling the role of a judge?
Chief Justice, there are various things, but it is to dispense justice and to uphold the Constitution and the constitutional values, and to see especially the value of equality, as you've noticed in the news lately, past week or so, the judgment that I've given. Yes, that is most satisfying.
Yes. You know, some of us come to the bench, be members of political parties, belonging to all sorts of societies, holding views, strong views one way or the other. What is it that enables a judge to disconnect from previously held views that would otherwise cause him or her to be prejudicially disposed to some people?
Impartiality, Chief Justice.
How do you get to that point? Can I give you well, let me not give you an example. I'm just trying to relax you, by the way.
Yes,
That's
no, thank you for that. I need that.
Yes, I picked it up, so I thought we must just have a chat, a broad chat.
Chief Justice, it is to disabuse your mind from all other things and to be completely unbiased and to really apply legal principles, to apply the Constitution. And that is what guides us. That is what informs our decisions.
Let me make my inquiry clear. Say I'm an African person who holds strong views because of my political orientation, that almost every white person in South Africa is inclined to look down upon black people, to oppress, to be greedy. How do I connect with the new responsibilities that demand of me not to look at color, but to look at the issues? Say I'm a white person who believes, because of my orientation and because of our history, that black people are foolish people, lazy people, who just want to be sitting around and making babies. How do I disconnect from that wickedness and that foolish perception about others to being an objective person who serves all, regardless of color, gender, or creed, or a highly chauvinistic person who thinks women do not belong to the legal fraternity? I've had my first dean when we were doing Cause 1, 180 of us say, you people are so many. You are going to fail. Half won't be here. I see that even women are venturing into the law. How does that lawyer who suddenly becomes a judge disabuse his or her mind from these prejudicial dispositions? What happens? What must happen? Is it automatic, or is it something that must happen to get one there?
Chief Justice, first of all, anyone with that type of prejudice ought not to be on the bench.
But they do get it.
But when you are on the bench, of course, you will get two different viewpoints before you.
Yes.
And that is to be completely unbiased and to respect people.
Yes.
And also to listen to people, because both sides have views.
Yes.
And unless you can get to that point where you listen to both sides and you weigh up their arguments, their viewpoints, and then you apply the principles, the constitutional principles, the principles of law.
Yes.
And we are guided by so many authorities, fortunately.
Yes.
Yes, but in the first instance, I don't think anyone with that type of prejudice ought to be on the bench.
Yes. Except that it may be difficult to detect them, isn't it?
Yes, no, it may very well be.
People may prepare so well that you're impressed. As soon as they are on the bench, they say things that will shock you.
Yes.
Yeah.
And prejudice may be so, as I mentioned in a judgment recently, may be so latent.
Yes, it may be subconscious.
Yes.
Yes. Now, how has your acting instinct in the SCA prepared you now for this position you're applying for?
Chief Justice, since 2013, I've been in the SCA acting for 7 terms, all in all, almost 2 years.
Maybe just at that point, were you well received? Did you get a sense that you were unwanted? Did you get the support of all colleagues? Or were some somewhat hostile to your acting instinct?
Chief Justice, I was well received, and I enjoyed my time there, and I get along. In fact, it feels to me I belong there. I got along with all my colleagues. Of course, some colleagues better than others. But I was very well received. And each time that I go back, I am well received again and again.
Are there things about the SCA that you got a sense needed urgent attention or serious attention in the long run, or does the place require virtually no improvement?
Chief Justice, I think that court is very well run. It has been well run under the former president, and it is very well run now under the new president. And the changes that are being made are transformation changes and necessary changes. But as to the running of the court, and I've said that before at the previous hearing, I think that court is very well run. Everything is very structured. You know before every term exactly what is going to be expected of you, and you can prepare yourself accordingly. So, yes.
Well, this is the one opportunity and platform where you are allowed to boast without anybody accusing you of arrogance. Just boast a bit about your readiness and suitability for the position you have applied for.
Yes. I don't like to boast, but I will take the cue. Chief Justice, I was at the Johannesburg Bar for 20 years. I had a very busy practice, mainly commercial work. I've been a judge for 11 years. I am a judge in one of the most busy divisions in this country. I've written many, many judgments. More than 200 of my judgments are now being published. And I think I am academically and experience-wise very well equipped to take my 31 years experience now into the Supreme Court of Appeal. And also you'll have noticed from the comments received about me is I like to engage with practitioners when they appear before me. I respect people. So I think I can add value to the Supreme Court of Appeal, and I think especially with all my experience that I've gained over many years in most of the disciplines of law, that I can take that to the Supreme Court of Appeal and really to the benefit of this country.
Yes. Thank you so much. President Meyer?
Good morning, Judge Meyer.
Good morning, President Meyer.
Are you well?
I'm good, thank you. It's nice seeing you.
Good. You have an illustrious CV, and you have proved over time during your acting stints at the SCA that you have what it takes to be an appellate judge. I don't think anyone can contest that. But the challenge is one to which you yourself have just alluded. That transformation in that court, especially gender diversity, remains a serious challenge. Now, I want to ask you this unfair question, which I've put your competitors yesterday. Why should you be appointed over the women and black candidates vying for this very same post, who may not have had an opportunity to hone their legal skills as sharply as you have as a white male in South Africa? The simple question is, how do we transform the SCA without weakening its intellectual capacity? Because that is my conundrum, and that is the challenge of this body as well, I'm sure.
President Meyer, I don't think that is an unfair question. And I am on record in this commission, I've said that before also, that I believe absolutely in transformation. And the only reason why I make myself available is in case there's a slot for me. But that is what the commission needs to decide. And I know that you've got a very difficult function to weigh up all the different interests and to decide on who the candidate should be to be appointed. But for myself, yes, I absolutely believe in transformation. And once again, to refer to the judgment that I recently wrote that is so in the news, Chowan versus AMH and Imperial, that was one of the issues in that case. And yes, we must have transformation. We've come a long way, but we are certainly not there.
Thank you, Chief Justice.
Thank you, President. Commissioner Msomi?
Thank you, CJ. Morning, Judge.
Good morning.
Judge, I just want you to comment on the comment that has been made by the GSB. This is against the background of what you have just said about the number of judgments that you have written. This is what they have to say about you. The candidate appears to be a competent jurist, but has a relative paucity of reported judgments of substantial legal significance. What is your comment to that? What role, perhaps let me just expand on that question, what have you done over the last 11 years to develop our jurisprudence and also to develop our common law? Thank you.
Commissioner, this is an aspect that was raised before, previously at the hearing. The transcript is available. The difficulty is I've published more than 200 judgments now. What they meant by the paucity is simply that there are not so many, although there are quite a number, that have been published in the formal, in the JUTAS law report. So that is first of all what is meant. And with regard to the development of the law, you'll also see that there are other comments, especially the one written by the University of Cape Town, that I have developed the law with regard to especially constitutional rights with regard to children. I've developed the law with regard to now gender discrimination and many other aspects. Also, some of the judgments that I've written are substantial: criminal law, administrative law, and many are mentioned. So that that comment really has to do with the fact that the law report simply cannot accommodate all the deserving judgments. That is what that comment is about.
Thank you. The second and last question is, and it's a question that I put to another candidate yesterday, and that is the observation about the SCA being a court of law, almost strictly, and not looking beyond or crossing the Rubicon to deal with issues of equity. One, is that observation correct? Two,
Can you just repeat that, Commissioner, please?
the issue that I'm raising is this, is that there is a general view that the SCA is a court of law, almost strictly court of law, whilst the Constitutional Court would look beyond issues of law and look at issues of equity. And there are many decisions which have been decided by the SCA which get overturned by the Constitutional Court on the basis of equity. And probably the most famous of them all was the Vodacom case, commonly known as Please Call Me. The question that I'm asking you now is, if there is this constraint of crossing that Rubicon, of moving beyond law to look at issues of equity, how do we get the SCA to do that if you particularly were to be appointed to the bench, to look beyond issues of law and take into cognizance matters of equity, fairness, and so on? Thank you.
Commissioner, first of all, I think but the Constitutional Court is our highest court, and precedents from the Constitutional Court are binding on all of us. And indeed, the Constitutional Court, in a number of judgments, also in other aspects of the law, civil law, infusion of equity in the law of contract, and that creates precedent. And it is for all of us, for puisne judges, for the High Court, for all of us, to follow the example of the Constitutional Court and to indeed be guided by principles of fairness, by principles of the Constitution, also in our treatment of the common law, for instance. And that is what the Constitution also enjoins us to do, is to develop the common law in conformity with the constitutional values. So anyone appointed to the Supreme Court of Appeal must also have this frame of mind and see things with different spectacles on. And that is what we need to do. That is how we develop the law.
Thank you. Commissioner Nyambi?
Thank you, CJ. Morning, Judge.
Good morning, Commissioner.
With your illustrious CV reflecting your experience, I'm sure you're the right one to reflect about the trajectory of judicial transformation. And what will you feel still need to be done when it comes to transformation?
Well, Commissioner, if you look at the statistics that we have, the statistics, first of all, looks much better than it looked in 1993, and certainly it looks much better than it looked when I was appointed as a judge 11 years ago. But we are not there. And we must try to get there. We must endeavor to get there. And once again, to refer back to this judgment of mine that is so in the media now, where I criticized a huge public company for the very same thing that one of the subsidiaries at the relevant time of my of the case before me, the last 14 senior appointments that were made were all white people with white men with one exception. It simply is not right in our country. We must transform. And competence we have all over the country. That is also another thing. We have hugely competent, in this instance, judges from all different groups. I don't want to name names, but look, for instance, at the President of the Supreme Court of Appeal.
Can you share with us your worst or your low experience as a judicial officer?
Well, I don't think that there is really, that there was such an experience for me. There are obviously some cases that are more difficult than others. And the volume of the work, of course, also, we are under tremendous pressure as judges in all divisions, Supreme Court of Appeal, and I speak of for the Johannesburg division and the Pretoria division. But yes, there's a constant work pressure, but I would not really, I've never experienced a low as a judge that I can, now use as an example. Yes, sometimes one is a bit burnt out, sometimes one doesn't feel appreciated, that sort of normal human being feelings. But it's a very rewarding profession and career and position to fulfill.
Thank you, CJ.
Thank you, Commissioner Nyambe. Commissioner Didiza.
Thank you, CJ. Good morning, Judge Meyer.
Good morning, Commissioner.
How are you?
I'm good, thank you.
Good. I've just looked at some of your judgment that you yourself have mentioned as, not that they're important more than the others, but which you felt were significant. And I agree on one of them that you actually wrote as number one that relates to environmental law, the case between Harmony Gold and Free State
yes.
Department of Water Affairs. Looking at your judgment, and I just want to hear from you, what do you think will continue maybe to be a significance with regard to this judgment in respect of the interpretation of environmental law in South Africa?
Commissioner, that judgment is considered to be a very important judgment. And the reason for that being that those who pollute cannot run away. They cannot get rid of the company and then think that's the end of the world, and then the taxpayer must sit with the problem. So the principle really, the bottom line of that judgment is, he who participated in the pollution must pay, forever and a day.
Just as a follow-up, do you think that it would be good for those who are renegotiating the mining charter to actually look closely at that judgment?
I
Because
think so.
as part of the obligation of the mining companies and how we redefine the space of mining activities in our country, but also in the continent and globally. This is one of the elements that
Yes, I agree with you entirely.
Thank you, CJ.
Thank you, Commissioner. Commissioner Singh.
Thank you, Chief Justice. Good morning, Judge Meyer.
Good morning, Commissioner.
I just want to agree with you fully. We come from the same environmental background as Minister Didiza. I was MEC for Environment at one time.
Yes.
And I think it's important that you gave that kind of judgment because acid mine drainage is a serious problem,
Yes.
Particularly in the Gauteng area. And the polluter pays principle is one that I would support. But my question relates to, you completed your application form on the 8th of December. And at that time, there were 5 reserved judgments.
Yes.
Some of them about 4 months. And one matter, I think, was first introduced in 2014.
Yes.
Have you given those judgments? And
Yes, no, I've
what
already.
gave rise to the...
Commissioner, I'll tell you, yes. I see that the Johannesburg Bar actually looked at the time that I normally spend on reserve judgments, and according to their comments, on average, it's about a month. Now, what happened was during the June-July recess last year, I picked up pneumonia, and that is the prime time that you catch up with your outstanding judgments. And then the next term was a very busy term for me, and the final term last year, I went to the Supreme Court of Appeal. So I spent the entire recess period, December, January, catching up on those judgments, and they've all been given. And I can tell you at the moment I sit with 2 reserve judgments, and both are very recent. Both are a few weeks. Maybe one is a month, but they are very recent. So that was a bit extraordinary for me, but it was a snowball effect.
Thank you, Chief Justice.
Thank you, Commissioner Singh. Commissioner Norman?
Thank you, Chief Justice. Good morning, Judge.
Good morning, Commissioner.
Thank you. I'm one of the people who can actually confirm what you say when you preside, you become impartial, you don't look at who's appearing before you. I've had a pleasant experience of appearing before you.
Thank you, Commissioner.
Now, you have contributed to the cost material towards orientation costs for newly appointed judges, and you've put in there that was between 2012 to 2014. Is there any particular reason why you stopped?
No, I didn't stop, Commissioner, and in fact, it is whenever I'm asked to do it, and I've just been asked to become involved in a mentoring program. So no, I didn't stop. It was just...
That's okay. Thank you. Thank you, Chief Justice. Thank you.
Thank you, Commissioner. Just by the way, whatever happens, whether you're appointed or not, would you still continue to help us? Because we need as many judges as possible.
Absolutely, Chief Justice. There's no doubt in my mind.
Thank you so much. Thank you. Professor Ntlama?
Thank you, CJ. Good morning, Judge Meyer.
Good morning, Commissioner.
It seems that there are different experiences of judges when they go to the Supreme Court of Appeal, particularly the blacks and the white ones. As a white judge, you were well received, but the black judges, there are issues that they raised on their reception at the Supreme Court of Appeal. Any comment on that one?
Commissioner, it is difficult for me to comment on that, but what I will say is, as far as myself is concerned, and President Meyer will bear me out, I have always been very well received by all my colleagues, blacks, whites, Indians, and I also like to make a point of mixing with all my colleagues there. But I will never doubt if any of our colleagues who acted there has those kind of complaints, it may very well be very valid. I was just never a recipient of that type of conduct.
Thank you, Prof. Minister?
It was a sabotage from Honorable Malema. Isn't he the obvious culprit? Good morning, Justice Meyer.
Good morning, Minister.
I see you have practiced as an advocate for almost 2 decades before you acquired silk status.
Yes, Minister.
Now, my question, and it's going to be only one question, it confines itself to that issue of acquisition of silk status. Now, I need to paint the following picture, and I hope I stick to my time. In 2014, out of 9 candidates for silk, 2 were African black male. the remaining 7 were white male. Now, in 2017 last year, and that was at the, I think, Johannesburg bar, in 2017, at the Pretoria bar, there were 8 silk candidates. 1 was black male, 2 women white. And finally, again in 2017, out of 16 candidates, 4 were black generic. Of the 4, only 1 was African, is it female? And 5 were women generally. Now, I see, as I said, you took almost 2 decades to acquire silk status. What is it with the criteria that are used to determine suitability for acquisition of silk status that seems to make it almost impossible for other race groups to acquire that status, given its role as a stepping stone for higher office and call it better pay in the profession?
Well, Minister, those the statistics that you've just given are absolutely shocking. And the bar should reflect on itself. Because whatever criterion is being used, and I can't comment on the criterion, I don't know what criteria is used. Commissioner Kane here, who's a member of the bar and who was the previous chairperson of the Johannesburg bar, is in a better position to answer this. But all I can say from where I sit is that those statistics are shocking. It is absolutely, there is no reason why the bar cannot look like the bench do at the moment, and for the bench even to look better than it looks. We are not there yet, but those statistics are shocking. And I can tell you one thing. There are many, many very competent counsel, black, white, Indian. I don't want to mention names here, but there is something inherently wrong if those are with those type of statistics. It simply cannot be. It should not be, rather.
Apologies. I think that with your permission, Chief Justice, my point really is to get to the nub of it, to say that is the reality. How do we change this reality a quarter of a century into democracy? I always assume that the Western Cape is the worst culprit because there's simply not enough numbers. But I thought Gauteng, Johannesburg and Pretoria combined, we have some significant participation in the bus to be able to have the necessary pool to draw silk out of that pool. What is it that needs to be done to really turn the situation around?
Well, Minister, we need to pressure on the professions all across the country with those type of statistics. It is simply not. And also it's the professions, really, the attorney's profession and the advocate's professions, and also the academics, that really feed the bench eventually. And those statistics are simply, it ought not to be like that.
Thank you, Minister. Commissioner Mpofu.
Thank you. Good morning, Judge Meyer.
Good morning, Mr. Mpofu.
Yes.
Commissioner Mpofu.
Thank you.
Sorry, I'm used to you in court.
I know, and also at the bar.
And at the bar, of course, yes.
Thank you very much. I'd like to just preface my question. We're not supposed to, according to the CJ, give long preambles. So I'll exchange my preamble by asking one question. But it's almost a follow-up on what the minister has asked you. By the way, as you know, I represent the GCB and Advocates for Transformation.
Yes.
So it's a transformation question, really. I just think that there is a problem. If we're going to look at this question of transformation of the bench and of the profession generally, at the tail end, by looking at the statistics that the minister has just given you, for
Yes.
example, the statistics of the bench and the SCA and all that, yeah. I think that's just the wrong way of looking at it. Obviously, that's important because that's the end product. Now, one of the key issues is clearly that access to work is not given to black practitioners, advocates and attorneys, and particularly black women practitioners. There are, in my book at least, the two culprits are the big white firms, historically white firms, and the state that don't give that. And most of the judges from that vantage point can see the people who appear before them. Our Chief Justice, I think, never spares any moment whenever he's speaking in public to lament that state of affairs of not giving opportunity. Now, apart from those kinds of public speeches, what role can the bench play in nudging the profession, the state, and all sorts of people, for understandable reasons, who might be reluctant to give work to black people for the historical reasons that we know, into making sure that those people are given the platform, are given the opportunity to do the difficult cases, the so-called obscure areas of law, so that these statistics can then be, the changing of the statistics follows almost as a normal course of events. Thank you. Thank you, CJ.
Commissioner Mpofu, did I understand you correctly? What you want to know from me is what role can the bench play as opposed to other institutions? Because one thing that I think with these type of statistics is RAF work, for instance, or to go to the junior bar. It's mostly for work for. But yes, as far as the bench is concerned, I think we judges must become actively involved with the professions, inside and outside of court. And we should absolutely promote transformation in that sense also. And I don't think that will detract on our objectivity. In fact, that is one of the constitutional imperatives.
Thank you, CJ.
Thank you, Commissioner Mpofu. Commissioner Fourie?
Chief Justice, thank you. I think I've been covered.
Thank you so much. Commissioner Nokesi?
Thank you, Chief Justice. Only one question. Judge, there is a tendency by the courts to treat the customary law as an inferior branch of our legal system, notwithstanding the instructions in the Constitution to apply the customary law. Firstly, I want to hear from you whether have you had an opportunity to deal with a customary law, with a matter that relates to the interpretation of customary law? Or what is your view to the statement that I just made?
Yes, first of all, in the urgent court, Commissioner, we are sometimes exposed to it within the context of funerals. And so my exposure to it so far was very limited. It was limited really to decide where a body should go to and who needs to have the say as to the funeral and where the body should be buried. But yes, of course, we need sensitivity about that. We need to accommodate because that's a very important part for many people, many millions of people. But my exposure as such is very limited to funerals, really.
You, Judge. Judge, the last question would be really just to find out, I mean, the Chief Justice and some of my colleagues have engaged you on this. You delivered a very important judgment in that case, which concerns Mr. Mark Lamberti
Yes.
on gender discrimination. What lessons, I mean, to us and the society really in dealing with these issues of racial and gender discrimination? How best can we deal with those matters as the society?
Well, I think that case is reported by some an academic as one of the benchmark decisions thus far. And I think that, you know, we can simply not countenance that sort of conduct anymore. And there's a duty on us judges in order to set the tone as far as the law is concerned. And already, just to answer the second part of your question, there's a suggestion in the media that the Companies Act should be amended to disqualify directors who contravene certain laws. And that may be something for especially the politicians to look at, because that will require an amendment of the Companies Act.
Thank you, Commissioner Nokesi. Commissioner Kane.
Good morning, Judge.
Good morning, Commissioner Kane.
During your answer to the Minister, you referred to my role on the Johannesburg Bar Council, and so I think it is incumbent on me to mention before this Commission that in 2017, there were 10 people recommended for silk by the Johannesburg Bar Council. 4 of them were white men, 3 were African men, 2 were white women, and 1 was an Indian male. In relation to the 4 white men, who are self-evidently then in a minority, they were all people who'd contributed enormously to transformation at the bar. Perhaps you would like to comment on that.
Well, I'm very pleased to hear that, because the statistics mentioned by the Minister are shocking.
Thank you, Judge. Meyer. Is it Meyer or Meyer? How do you best prefer it?
It's Meyer.
Meyer or Meyer?
Yeah, Meyer.
Okay, Meyer. Thank you, Judge Meyer. You are excused.
Thank you, Chief Justice, Commissioners.